double barrel gun. You start with Om Prakash, senior advocate.
Very good evening to all of you. Respected President, Secretary of MBA, Office Bearers, and my dear friend Mr. Srinath, who has agreed to share this burden of mine today. We were supposed to have a lecture on art of advocacy. Probably we may today witness a ulta situation of that. End of the day, you may have to ultimately vouch for the fact whether there is anything as an art of advocacy between these two seniors, or we just stood by to take some time of your evening. For some reasons, the convener of the Tamil Nadu Senior Advocates Forum, Mr. Somyaji, could not make it today. So that lecture of his on art of advocacy will be on some other day. It is only postponed. As the event had already been scheduled, we don't want anybody to be disappointed. So we thought we will have some sharing of thoughts on some subject. By lunchtime, I had a call with Srinath saying that this situation we may have to redeem and do something. And I was also desperately trying for Mr. Parthasarathi sir, hoping that he will be always available to give a lecture on some provision of CPC. You take one section, probably he can take it for 1 hour. You take one order of the CPC, he may take it for 2 days. So, on a lighter sense, when I said that I had been desperately trying for you, he said, good that you did not reach me out. So, by the time we could finalize all those things, myself and Srinath decided that we will play the game in terms of whatever we are good at. So I told Srinath that we will share some thoughts or give some insights on statutory remedies. Immediately Srinath said, yes sir, you will be good at IBC, I will be good at SARFAESI. Both of us can do something on DRT. So he said we can work on it, it's not a problem. So he had taken pains, in fact spent about 1 hour taking out all the judgments, everything. So I said, I will just put a line and you may have to make it as a good roadmap for the day. So when we speak about statutory remedies, we may have to look at what we actually mean about remedies. Any right should result in a remedy. There is no point you have a right but you don't have a remedy. So this evolves to a situation as to every right should result in a remedy, and where do you seek for this remedy? You need to have a judicial administration, you need to have courts for that. So over a period of time, how this evolves as that, something which we have borrowed from the English law is called the common law remedy. The English courts devised saying that the remedies are available in common law. No statute or no provision is specifically need to provide you that you have to go and seek for a particular remedy. Your procedural laws will be there, your substantive laws will be there, but as to remedies, you can seek for any remedy for redressal of your injury to a right, and that is called as common law remedy. When we speak about common law remedy, we immediately get into the mind of approaching a civil court. You know the hierarchical system, you have civil courts. Civil courts enable you to file a suit. Now section 9 of Civil Procedure Code specifically says that a person can approach a civil court for any remedy. In addition to that, what it says is that unless barred by any statute. So only consideration which is there is that while you seek for a remedy before a civil court, it should not have been barred by a statute. Therefore, this takes us to the topic of the day. If a particular statute bars a remedy, which would mean that the statute is going to provide you some remedy. So therefore, specific statutes came into place. Those statutes devised what rights an individual can look at upon. Those statutes to some extent regulated the rights which are available for individuals, and it provided a mechanism as to what can be the redressal for such rights, remedies to be worked out. Then these statutes, the moment it recognizes some specific subject or area and provide for a remedy, they also said that there should be a bar of the civil code. That is where you will fall back to section 9 of CPC, which says unless there is a specific bar under statute. So if a statute provides for a remedy, it would naturally, as a corollary, what it will do is that there will be a bar insofar as the common law remedy is concerned. Now, then it takes us to the point as to if there is a remedy which is provided in the statute, what is the forum which you have to look for? If you look at this march of law, special enactments came, special enactments recognized special rights, special enactments provided for specific remedies. Now, in the earlier point of time, you will find that the forums which have to provide these remedies were again identified by a name but vested with the civil codes. Your common example can be when the Rent Control Act came. It provided a specific remedy for the landlord and tenant. It said there will be a rent control appellate authority. But ultimately the normal civil courts, for example, you take the small cause court at Chennai and you take the subordinate courts at the districts, these courts were notified to function as rent control courts. These courts were notified to function as rent control appellate courts. Then over a period of time, these statutes started recognizing special forums. They created special forums in the nature of either at the first instance authorities and thereafter it were in the nature of tribunals. When we speak about authorities, earliest statute which you can look at is that endowment boards, land administration boards, land administration authorities. These were all created by special statutes. You had specific remedies there. So therefore, the march of law, the flow of system is such that your common law remedies took to a shape of statutory remedies. These statutory remedies under special laws recognized specific forums. Initially these forums were the regular civil courts being designated or notified as forums under the statute, and then comes the tribunals which have been established under different laws. So this is the context in which I thought we will have some sharing of thoughts. More recently what we find is that more than our regular courts, most of the work is aligned towards the tribunals. You had this system of banks and financial institutions seeking recovery by filing suits before civil courts. Once the DRT Act came, the entire civil court's jurisdiction in respect of adjudicating the bank dues, adjudicating the recovery mechanism was now vested with a tribunal called Debt Recovery Tribunal. Then once the DRT Act, after a period of time, took shape in the nature of a SARFAESI Act, where the bankers were given the right to invoke by themselves the security interest. Again, the adjudicatory mechanism was provided before the DRTs. Now these statutes, and now thereafter you will have the insolvency and bankruptcy code. Without getting into various enactments or various other statutory remedies, for an understanding of how the statutory remedies work, let us look at these three different statutes. Now, when I say about it this, at the first instance, I said about section 9 of the CPC. Just see one of the oldest judgment. It is reported in Law Weekly 1931, Part 5, page 209. A judgment of the year 1931. I'll just read few lines. This was a case which was relating to the Board of Commissioners for Hindu Religious Endowments. An issue as to whether the board has power or a civil court has power to decide a particular dispute was the question when consideration. So in that what they said is that thus a determination or order which is in excess of jurisdiction conferred upon the tribunal would be liable to be set aside by a suit or by the court in exercise of its powers under the revision as the case may be. But the well established principle is that when by an act of legislature powers are given to any person for a public purpose for which an individual may receive injury, if the mode of redressing the injury is pointed out by the statute, the jurisdiction of the ordinary courts is ousted, and in the case of injury the party cannot proceed by suit. So as early as 1931, this recognition of remedies provided by special statutes was considered. And it said the moment a statute provides a specific remedy, the jurisdiction of civil courts is ousted. Now I was referring to the march of law in respect of the special remedies and statutes. One another point which you can look at is that at least till a point of time when the special statutes provide certain remedies, it also recognized to some extent the powers of the civil court. Example, if you have to look at even under the Hindu Religious Endowment Act, there are certain issues which ultimately if the commissioner is not able to decide, he may direct the parties to go before a civil court. Likewise, when I was saying about DRT Act, the recovery mechanism under the DRT Act is in terms of second schedule to the Income Tax Act. Those provisions have been read into, and the recovery officer exercises his power in terms of the second schedule of Income Tax Act. Now the second schedule under Rule 11 recognizes an adjudicatory mechanism by the recovery officer. So if there is any dispute or if there is any issue as to a right to a property which the recovery officer is seeking to proceed with, you have a right to approach the recovery officer by filing a petition under Section 11, Rule 11. Now this Rule 11 also recognizes a point that the recovery officer may ultimately direct the parties to go before a civil court and decide their rights. So in this march, there was at least a recognition in terms of referring the parties to the civil court for a dispute to be ultimately decided as regarding rights to property or individual rights. But of late, even this is not done. Now when I say about these things, each of the statutes will definitely speak by a particular provision as to what is the jurisdiction which it has to exercise, what is the remedies which it can provide. So a jurisdiction to that particular tribunal or an adjudicating authority will be recognized by the statute. So within that jurisdiction, whatever remedies which has to be provided will be recognized by the statute, and that statute will say that this remedy can be obtained from a particular forum. So this is how it works. Now having said this, statute will also put in a word that there will be a bar of the civil court insofar as the jurisdiction which is vested upon a particular tribunal or authority under that particular statute. So where the interplay comes is that as to this jurisdiction, arriving at this jurisdiction, whether on a particular cause, do I have a remedy within that statute which is provided before a particular forum, or whether I have to go back to the civil court and seek for this remedy. So as I said, from the earliest point of time, you will have judgments which are running from 1931. Now when each of the statute, as I said, recognizes a jurisdiction, bars a jurisdiction of a civil court, it provides a remedy in a particular provision. It would say that what is that you can seek. For example, if you take DRT Act, Section 19 is the section which speaks about the remedy. The banks or financial institutions can come before the tribunal, seek for a relief in terms of Section 19. And the jurisdiction of the DRT is specifically provided under Section 17 and 18. So it cannot go beyond that bounds. It has to work within that bounds. And remedy is in terms of Section 19. Appeal in terms of Section 20. This is how it proceeds. Now, is there any other thing which is still left behind? As we find in general, as a first rule of principle, whenever there is a vesting of a right with a particular forum, there will be always a provision which speaks about residue powers, which is normally which we look at kind of interim orders or interim protections, whatever it is. Beyond this, every statute will also recognize a kind of residue powers. These residue powers will be specified to the extent for the purpose of ensuring justice is done. Ultimately, these are the barriers or words which are required. in the interest of justice, if a particular order has to be passed, if it has to be ensured that the provisions of the Act is being complied with, there is a residuary power which is left with. Each of the statute also recognizes. Now, SARFAESI I will not touch because Srinath had said he is going to deal with SARFAESI Act. The next will be Insolvency and Bankruptcy Code. Now, a background to that, you would all be knowing that whatever earlier enactments which were there on individual insolvency, winding up proceedings in respect of companies, and all these restructuring, rehabilitation process provided under the Reserve Bank of India Act, as well as the Sick Companies Act, all those things were consolidated and a single statute was brought in the name of a code. Now, the remedies as far as Insolvency and Bankruptcy Code was again left with a specialized tribunal called NCLT. Now, as in all cases, the code also says that there will be a bar of jurisdiction of civil court. And as I said, as a residue provision, the code also recognizes, insofar as NCLT is concerned, section 60, subsection 5, which says if there is any question of law or fact to be decided, it would be only NCLT. Now, none of these provisions or any rules concerning this does not leave any scope for a civil court to decide. So that is where the conflict comes. You may have an unique situation where you may have to establish a right. Take a case where you may have to have a declaration of a right. Unless that right is declared, you may not be able to exercise that. This declaration, in terms of the specific relief act, we always go back to the civil court and seek. Now, if this declaration is going to be in conflict with some enforcement under the special statute, what happens is a question. Now, this remains a kind of a grey area in terms of the statutes which are a kind of a new age laws which have come into place. It doesn't still give you any scope. Probably Srinath will throw you more light when SARFAESI Act came, to what extent Supreme Court had gone on this provision as to whether you can go before a civil court. He will deal with it. Now, coming back to these IBC provisions, today very many situations in an insolvency of a company, be it workman's claim, be it claims by any person who had rendered service, be it claims by person who had supplied goods, statutory dues, government dues, property tax dues, electricity dues, everything will have an implication in insolvency resolution. Now, how this is to be dealt with and what is the remedy which we can look at, the code only says it is the NCLT. You don't have any other scope where you can look back. So that is how the statutory remedies have taken a shape. Now, let me show you one judgment. Now, before I go for one judgment on the statutory remedies, one interesting point which you can look is that every statute, when it comes, you have cases where there are challenges to the virus of the either the provisions or the statute as a whole. So when Insolvency and Bankruptcy Code came, the Supreme Court was flooded with so many cases, high courts were flooded with cases, and ultimately the Supreme Court decided the matter as to the virus of the statute in the case of Swiss Ribbons, which is reported in 2019 4 SEC page 17. Swiss Ribbons Private Limited versus Union of India. So many issues were taken up in this judgment as to a threadbare analysis of various provisions of the IBC. Each of the provision was put to a test, whether there was any discrimination, whether it satisfies the tests as to the constitutional guarantees. For example, section 12 capital A of IBC provided that once an insolvency is commenced, there can be a withdrawal of this insolvency. But it came with a rider saying that this withdrawal can happen only if there is a resolution by the financial creditors to the extent of 90%. So one of the challenges was that this is highly discriminatory, arbitrary. A person who files a case, as we know in a common parlance, you are always entitled to withdraw. But in an IBC proceedings, the moment a CIRP has commenced, there is no question of withdrawal. So initially the court did not have any provision. Supreme Court in one case found that ultimately a person is settling all the debts. If that is the case, why should still it go? So therefore, in that case, the Supreme Court suggested that the legislature may have to look into, and it exercised the powers in terms of Article 141 and said that we are deciding this case as closure. Then came 12A. So this was also put into test. There was one more situation which is again by an amendment which came under the IBC, is section 29 capital A. where they found that there should be some disqualification provided for this defaulting borrowers or delinquent promoters who had been the reason for the insolvency of a company. They should not be given an opportunity to come back as a resolution applicant. Therefore, section 29 capital A came. So this was also put into test. So this Swiss ribbon, if you just go through that, it will give a clear insight as to challenges to provisions, challenges as a whole to the statute. Now for the present, I am not going to take into all those things. Now after the Supreme Court discussed all these provisions and gave its decision as to the virus of the enactment, the final one paragraph is more important, which I have to share with you. In paragraph 120, this is what the Supreme Court records. The Insolvency Code is a legislation which deals with economic matters and in the larger sense deals with the economy of the country as a whole. Earlier experiments, as we have seen in terms of legislations having failed, trial having led to repeated errors. This trial is put in within inverted commas. Having led to repeated errors is again within inverted. Ultimately led to the enactment of the code. The experiment contained in the code, judged by the generality of its provisions and not by so-called crudities and iniquities that have been pointed out by the petitioners, passes constitutional muster. So an approval as regarding the statute. To stay experimentation in things economic is a grave responsibility, and denial of a right to experiment is fraught with serious consequences to the nation. Now in the earlier paragraph, Supreme Court discussed about what it says about right to experiment and the denial of right to experiment. This denial of right to experiment in terms of Supreme Court is to the legislature. It said when the code came, yes, of course there were certain shortfalls, and Supreme Court recognized the fact that they have built in a mechanism as to periodically revisit whatever it is happening by having a permanent committee on the legislative intent. And in terms of whatever suggestions which are coming from the committee, amendments have been made. So considering that, they said to stay experimentation in things economic is a grave responsibility, and denial of right to experiment is fraught with serious consequences to the nation. We have also seen that the working of the code is being monitored by the central government by expert committees that have been set up in this behalf. Amendments have been made in the short period in which the code has operated, both to the code itself as well as to the subordinate legislation made under it. This process is an ongoing process which involves all stakeholders, including the petitioners. So in a challenge to a statute, what Supreme Court ultimately said is that insofar as economic legislations, the intervention of court should be minimum. It also recognized the fact that even legislature have this concept of experimenting and coming up with changes which are required. And then they said, even a petitioner who challenges is part of the stakeholder, you may also have a role in shaping of the law. So this I just wanted to point out as to when we speak about the statutory remedies, what happens. Now I have said about exclusion of civil court jurisdiction in all these special statutes. This brings about one more question as to if civil court jurisdiction is excluded, whether the jurisdiction of the High Court in exercise under Article 226 and 227 is also excluded or not. Now what is relevant, take these three statutes alone, take DRT Act and SARFAESI Act. These two statutes give a finality with the decision insofar as the forums created. Beyond that, there is nothing. You challenge a SARFAESI measure, go to the DRT, there is a decision. Appeal is provided to the DRAT. Thereafter, the Act does not recognize any further challenge. Then what is left is that as to the illegality in this decision or as to the adjudication which failed to consider your points, you may have a limited jurisdiction of approaching the High Court under 226 or 227. 226 may be a case where you question the finality of the DRT or DRAT decision. 227 may be a case where you question as to the procedures or adoption of the procedures by these specialized tribunals. Now when you come to IBC, the mechanism is that your first court is before your first remedy is before the NCLT. After an NCLT, you have an appeal remedy before the NCLAT, as against which court recognizes an appeal only to Supreme Court. Now in change to these two statutes, the latest statute says an appeal to Supreme Court, earlier which was not there. Likewise, there are very many legislations which have now come, which are completely bypassing this process of whatever adjudication, whatever rights you agitate before a high court under Article 226 or 227. So this is one area which again has to be looked into. Now, having said this, let me point out one case of the Supreme Court, which is the case reported in 2020-13 SEC, page 308, titled as Embassy Property Developments versus State of Karnataka. Brief facts is that there is a company which is undergoing a corporate insolvency resolution in terms of orders of the NCLT. A company which was having a registered office in Tamil Nadu, therefore NCLT at Chennai had exercised the jurisdiction. This company had certain mining lease in the state of Karnataka. Now, after the commencement of the CIRP, the authorities under the Mines and Minerals Act had passed an order cancelling the license or lease, whatever it was there, in respect of this company. Now, once a corporate insolvency resolution starts, that is CIRP commences, there is a moratorium which is recognized under the code, which says that no other authority, no courts, nobody can proceed with any matters which are concerning with the particular company. So when a license or a lease of the mining activity was cancelled, the concerned person thought it fit that it is the NCLT which has to ultimately decide. So they go before the NCLT and point out that there is a moratorium. Therefore, the state of Karnataka could not have cancelled. They also point to the fact that this license is one of the asset of the corporate debtor, which is subjected to insolvency resolution. Therefore, even if they want any remedy, they should have come only before the NCLT. NCLT accept this, and there is an order setting aside the order of the state of Karnataka, cancelling the mining lease. Now, as against this order of NCLT, state of Karnataka choose to approach the High Court at Karnataka by filing a writ petition under Article 226. And there is a stay of the NCLT proceedings granted. Writ was still pending. Now, at that stage, one of the parties go before the Supreme Court and say that High Court should not exercise its powers under Article 226 because the statute recognizes appeal remedy. At the most, they should have gone before the NCLAT or recognize the fact under the code the adjudication can be only by NCLT and appeal remedy before NCLAT and to the Supreme Court. So this case came before the Honorable Supreme Court and consideration. Ultimately, the decision on the case was on a point saying that a public law remedy cannot be in any manner taken away by a statutory remedy. It cannot be exercised by a tribunal created by a statute. This was the decision. Though it goes on so many things, what was recognized is that a mining lease is a kind of a public law. It arises under a particular enactment which is in the larger interest of the public, namely Mines and Minerals Act. If that be the case, NCLT being a body which is exercising its jurisdiction only under a particular statute, which has a jurisdiction which can provide a remedy only in related to that statute, cannot exercise any powers on the public law remedy. So this was the point on which what is interesting for us is, I will just read out what were the question which was considered before Supreme Court and 2-3 paragraphs which will throw some light as to the topic which we are considering. Question 1 was, in the backdrop of the facts narrated and the light of rival contentions extracted above, the first question that arises for consideration is as to whether the High Court ought to interfere under Article 226, 227 to the Constitution with an order passed by NCLT in a proceedings under IBC despite the availability of statutory alternate remedy of appeal to NCLAT. Now, with this question, the court had also considered as to the jurisdiction, everything. There are 2 or 3 important paragraphs which takes into consideration the march of law and various judgments. Now, in paragraph 15, one of the well-recognized exceptions to the self-imposed restraint of the High Courts in cases where a statutory alternate remedy of appeal is available is the lack of jurisdiction on the part of the statutory quasi-judicial authority against whose order a judicial review is sought. Traditionally, English courts maintained a distinction between cases where a statutory quasi-judicial authority exercised a jurisdiction not vested in it in law and cases where there was a wrongful exercise of available jurisdiction. So a 2 distinction was brought. One is that, as I said, if I take a DRT Act, section 17, 18 will define as to what is the jurisdiction. If you take SARFAESI Act, it will again define as to what is the jurisdiction. So they said two situations. One is there is lack of jurisdiction, therefore a wrongful exercise of jurisdiction, in which case High Court can interfere in terms of 226, 227. The other case which they see is that cases where there was a wrongful exercise of available jurisdiction. Then it says an error of jurisdiction was always distinguished from in excess of jurisdiction. Until the advent of the decision rendered by House of Lords by a majority of 3:2 in Animisnick Limited versus Foreign Compensation Commission. After acknowledging that a confusion had been created by the observations made in R versus Governor, to the effect that if a tribunal has jurisdiction to go right, it has jurisdiction to go wrong. It was held in Animisnick that the real question was not whether an authority made a wrong decision, but whether they inquired into and decided a matter which they had no right to consider. Animisnick, hailed as a breakthrough and a legal landmark, abolished the old distinction between errors of law that went to jurisdiction and errors of law that did not. So in this English law, what they said that ultimately you cannot distinguish in this manner, that there is a jurisdiction but wrongly exercised, or that there is no jurisdiction. In spite of which they said a power of judicial review will be available. Animisnick was hailed in the subsequent judgment to have liberated English public law from the fetters that the courts had therefore imposed upon themselves so far as determination of inferior courts and statutory tribunals were concerned, by drawing exoteric distinctions between errors of law committed by such tribunals that went to their jurisdiction and errors of law committed by them within their jurisdiction. But Rascal Indri made a distinction between courts of law on one hand and administrative tribunal, administrative authorities on the other, and held that insofar as inferior courts of law are concerned, the subtle distinction between errors of law that went to jurisdiction and errors of law that did not would still survive if the decision of such courts are declared by a statute to be final and conclusive. So that is what happens in DRT and SARFAESI Act. If the statute declares that it is final and conclusive, dehors whether it has jurisdiction or it exercised a jurisdiction which was wrongfully, the judicial review power will be there. Thus one distinction was gone with Animisnick, but another was born with Rascal. This could be seen from the after effects in Animisnick. Interestingly, just 4 days before the House of Lords delivered this judgment in Animisnick, on 17/12/1968, an identical view was taken by a 3-member judge of this court, delivered on 13/12/68 in Official Trustee versus Sachidanand Nath Chatterjee, approving the view taken by the full court of the Calcutta High Court, full bench of Calcutta High Court in Rudranath Roy versus Ramchandra Barna Sharma. It was held therein, before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit, but must also have the authority to pass the orders sought for. So this was how our own high courts distinguished this issue by approving a full court view of the Calcutta High Court. So this distinctly brings about as to this powers of the High Court as far as 226 and 227. At the same time, dwells into the issue as to how statutory remedies have to be looked into. Now this becomes more academic because, as I said today, we are mostly driven to many tribunals. We are mostly driven to many authorities. Day in and day out, what you will find is that the moment you go with a writ petition, is there a remedy which is available under statute? If there is there, why should we exercise our powers under Article 226? So that is the context which I thought I will just share my thoughts. Being a very short and sudden lecture, this is what I could ultimately share with you. Thanks for your time with me, and it will be still continued by Mr. Srinath, who has come up with some more judgments as regarding the special tribunals referring to statutory remedies under the SARFAESI Act. Thank you.
Thank you. President, Secretary, friends, thank you. In Delhi, there's this concept of a second seat senior counsel, where the lead senior counsel will argue everything, and then I have to sit down. But I intend to do slightly more than that. So the thing is this, the interesting thing about bar of suits is that you find that it first starts in the 1930s with a Privy Council judgment called Secretary of State versus Mask. Now if you ask yourself, why does it start like this? You come to a very interesting finding, which is that the British started introducing bar of suit provisions only as Indians started manning the benches. And presumably they had less faith in our ability to adjudicate their laws to the people whom they considered their subjects. And therefore they brought in a bar of suit provision. I think the first such was in the District Municipalities Act of 1920, and that keeps getting carried forward in act after act. So you have Secretary State was Mask, then you have Raleigh, and then after independence we have slavishly followed the same thing. And why do legislatures not like the civil courts to adjudicate? This is something which I argued before. This is Parthiban in a case called Abibas. And my view is this. The sovereign, the king has three faces, which is the legislative, the executive and the judiciary. Now, when we go to the sovereign judiciary, which is the district munci for the district court, the high court, there is no fetter on their power to render justice, and they are not answerable to the executive for their tenure. Whereas a tribunal member is not in that position. However high the tribunal, could be a tribunal manned by a Supreme Court judge retired. But the fact is that there are certain powers which exist in the sovereign courts which a tribunal does not have. And it is my view that it is for this reason that the governments of the day prefer to have tribunals and prefer to divest powers from the sovereign civil courts. And it was for this reason that I argued before His Lordship that an arbitral tribunal, however, 3 retired judges of Supreme Court or whatever, cannot exercise the power of impleadment. And this was held in a case called Abibas, and recently followed by the division bench of Justice R. Subramaniam in a case argued by Mr. Kabir. And Abibas has also been followed by the Delhi High Court in a case called as Arupri. So this is the context from which you have to approach these bar of suit provisions. Bar of suit provisions are inserted by a legislature which does not want you to have recourse to sovereign courts, but prefer you to go to the tribunals of their choice. So, having set that context, let us look at how these bar of suit provisions have been interpreted. As I said, the starting point is Secretary of State versus Mask. Then, after that, you come to the next judgment in that line is something called Firm Illuri. Firm Illuri is 1963, volume 50, ITR, page 93, which is a 5-judge bench which decided a suit for refund of taxes illegally collected. So there's a bar of suit under the statute, to section 18, capital A. So why did they file the suit? They said, the plaintiff in that suit, Firm Illuri, said that this is a tax collected without any power in the statute at all. Therefore, there is no jurisdiction whatever to collect this tax. Therefore, a suit is maintainable. The Supreme Court held that while it is true that a civil suit is maintainable where there is a total lack of jurisdiction, it applies only where the power to assess itself doesn't exist. So the words used are, a suit will not lie for a wrong assessment or to correct an action taken, but only where the provenance of assessment does not exist. So that is Firm Illuri. Next is a judgment called Kamala Cotton Mills, which is 1965, volume 57, ITR 643, again 5-judge bench. Here they expand slightly more pro-citizen. Here they say every suit is maintainable unless expressly barred or barred by necessary implication. So when is it barred by necessary implication? They say it is not barred by necessary implication if, and they give 2 tests. The first they say is that you have to go through the scheme of the act. Can the relief you are seeking be granted by that specialized forum? And second, will the adjudication by the civil court do violence to the scheme of the act? So that is Kamala Cotton Mills. Next comes the most often quoted judgment, which is called as Dulabai. Dulabai is 69 Supreme Court, page 78. In Dulabai, the Supreme Court lays the tests which have been followed ever since then, all the way till today, where they say, again, express bar is a complete ouster of jurisdiction. Implicit bar, they say, you have to look whether there is a hierarchy built into the statute by which you can seek your remedy. If there's a hierarchy, the civil court is barred. Whether it's right or wrong is not up to debate because it's a 5-judge bench. But Dulabai holds the field till today, and you will find that this is repeated again and again. Now, as our senior Mr. Om Prakash said, within a statute there is still scope to file civil suits or approach the civil court, but it is within a very narrow compass, and in all other cases you only have to look to the constitutional remedy of Article 226. Now, Article 226, to me, to talk about it being barred itself is impossible, because ever since the Constitution bench in Chandrakumar, I think no one can, it is almost elevated to the position of basic structure. You cannot have anything which bars 226, and today, in my view, I think even a constitutional amendment which whittles down 226 will be struck down as violative of basic structure. While researching for this talk, I came across one very interesting judgment, and I'll trouble Patsati sir for the citation after this. There is a judgment of a High Court rendered by His Lordship Justice Ismail, saying that in all these Inam Acts you have an STA, Special Tribunal Appeal. Thus Ismail has held that a writ is maintainable against the judgment of the STA. So he says that it may be 2 judges of High Court, but it's just a tribunal. So 226 is all pervasive. To the same effect is a judgment, 1955 Madras in re Hayes, where in those days industrial tribunal used to be a single judge of the High Court. There is a judgment of a High Court holding that a writ petition lies against a judgment of a single judge, though he be acting as a tribunal. They say if you are acting as a tribunal, you are not a High Court. The High Court is always sovereign. So nothing can whittle down or dilute the powers of a High Court. So having looked at remedies, like I said, in my view, we should always interpret them expansively. We should be looking for ways in which a remedy can be given, and not looking for ways by which we can hem in close our arms to a suitor seeking justice. We should always look for ways in which somehow the power can be stretched to give some relief to the person who's come to court. So having said that, I'm going to swing to the exact opposite and tell you what are all the traps that bank lawyers like me will lay for you if you file cases under SARFAESI Act. So when we talk about the bar of suit under the SARFAESI Act, there are 2 sections you should look at. One is section 18 of the RDB Act, which says that no suit will lie in respect of matters which a debt recovery tribunal is competent to give relief. And 34 says the jurisdiction of civil court is barred in respect of matters covered by this act or which a tribunal under SARFAESI Act is competent to do. This was first interpreted in Mardia Chemicals. I'll give the citations later if you want, or I can give it now. It's 2004, volume 4, SEC 311, which says that suit is barred, but in very rare cases, such as fraud. So obviously there is some implication that there is a case other than fraud in which a suit is maintainable. What that is, I have not seen yet, but that is Mardia. So after Mardia, you had people taking recourse to civil, only to the DRTs. But you also had a case where every person, so there were a lot of people who said, the bank promised me 100 crores, they only gave me 30 crores, so my business failed, so I'm going to make what is called the lender liability claim. So then the question arose as to whether this suit is maintainable or not, or whether we can only the DRTs has jurisdiction. All of this came before a bench of the Honorable Supreme Court called Nahar Industrial Syndicate, which is 2009, volume 8, SEC 646. There Supreme Court said counterclaims are maintainable and DRT does not bar the jurisdiction of civil court to decide a lender liability claim. So this obviously led to a lot of people filing suits before the civil court. So the legislature jumped in tried to amend the RDB Act by giving power to receive and hear counterclaims. So then the question arose as to whether after the amendment, suits filed in civil court can be tried as counterclaims for the DRT. That in a very recent judgment, Honorable Supreme Court in a case called Bank of Rajasthan versus VCK Broking, which is 2023 volume 1 SEC page 1, has said that the civil court's jurisdiction is still not barred and suits filed for lender liability claims will not be transferred to DRT. So now let's go back now to, we left off at 2009. So after the SARFAESI Act came to be fully enforced, we had, when I say we, I mean bank lawyers, we started seeing people filing partition suits, suit to declare the mortgage is null and void, suit to declare that the mortgage was given without proper authority. These kinds of suits started to be filed before the civil courts. So the question is, Arupri. So this is the context from which you have to approach these bar of suit provisions. Bar of suit provisions are inserted by a legislature which does not want you to have recourse to sovereign courts but prefer you to go to the tribunals of their choice. So having set that context, let us look at how these bar of suit provisions have been interpreted. As I said, the starting point is Secretary of State versus Mask. Then after that you come to the next judgment in that line is something called Firm Illuri. Firm Illuri is 1963 volume 50 ITR page 93, which is a 5-judge bench which decided a suit for refund of taxes illegally collected. So there's a bar of suit under the statute, section 18 capital A. So why did they file the suit? They said, the plaintiff in that suit, Firm Illuri, said that this is a tax collected without any power in the statute at all. Therefore, there is no jurisdiction whatever to collect this tax. Therefore, a suit is maintainable. The Supreme Court held that while it is true that a civil suit is maintainable where there is a total lack of jurisdiction, it applies only where the power to assess itself doesn't exist. So the words used are, a suit will not lie for a wrong assessment or to correct an action taken, but only where the provenance of assessment does not exist. So that is Firm Illuri. Next is a judgment called Kamala Cotton Mills, which is 1965 volume 57 ITR 643, again 5-judge bench. Here they expand slightly more pro-citizen. Here they say the every suit is maintainable unless expressly barred or barred by necessary implication. So when is it barred by necessary implication? They say it is not barred by necessary implication if, and they give 2 tests. The first they say is that you have to go through the scheme of the act. Can the relief you are seeking be granted by that specialized forum? And second, will the adjudication by the civil court do violence to the scheme of the act? So that is Kamala Cotton Mills. Next comes the most often quoted judgment, which is called as Dulabai. Dulabai is 69 Supreme Court, page 78. In Dulabai, the Supreme Court lays the tests which have been followed ever since then, all the way till today, where they say, again, express bar is a complete ouster of jurisdiction. Implicit bar, they say, you have to look whether there is a hierarchy built into the statute by which you can seek your remedy. If there's a hierarchy, the civil court is barred. Whether it's right or wrong is not up to debate because it's a 5-judge bench. But Dulabai holds the field till today. And you will find that this is repeated again and again. Now, as our senior Mr. Om Prakash said, within a statute there is still scope to file civil suits or approach the civil court, but it is within a very narrow compass, and in all other cases you only have to look to the constitutional remedy of Article 226. Now, Article 226, to me, to talk about it being barred itself is impossible, because ever since the Constitution bench in Chandrakumar, I think no one can, it is almost elevated to the position of basic structure. You cannot have anything which bars 226, and today, in my view, I think even a constitutional amendment which whittles down 226 will be struck down as violative of basic structure. while researching for this talk, I came across one very interesting judgment, and I'll trouble Parsati sir for the citation after this. There is a judgment of our High Court rendered by His Lordship Justice Ismail, saying that in all these Inam Acts, you have an STA, Special Tribunal Appeal. Thus, Ismail has held that a writ is maintainable against the judgment of the STA. So he says that it may be two judges of High Court, but it's just a tribunal. So 226 is all pervasive. To the same effect is a judgment, 1955 Madras in re Hayes, where in those days industrial tribunal used to be a single judge of the High Court. There's a judgment of a High Court holding that a writ petition lies against a judgment of a single judge, though he be acting as a tribunal. They say if you're acting as a tribunal, you're not a High Court. The High Court is always sovereign. So nothing can whittle down or dilute the powers of a High Court. So having looked at remedies, like I said, in my view, we should always interpret them expansively. We should be looking for ways in which a remedy can be given and not looking for ways by which we can hem in close our arms to a suitor seeking justice. We should always look for ways in which somehow the power can be stretched to give some relief to the person who's come to court. So having said that, I'm going to swing to the exact opposite and tell you what are all the traps that bank lawyers like me will lay for you if you file cases under SARFAESI Act. So when we talk about the bar of suit under the SARFAESI Act, there are two sections you should look at. One is section 18 of the RDB Act, which says that no suit will lie in respect of matters which a debt recovery tribunal is competent to give relief. And 34 says the jurisdiction of civil court is barred in respect of matters covered by this act or which a tribunal under SARFAESI Act is competent to do. This was first interpreted in Mardia Chemicals. I'll give the citations later if you want, or I can give it now. It's 2004, volume 4, SEC 311, which says that suit is barred, but in very rare cases, such as fraud. So obviously there is some implication that there is a case other than fraud in which a suit is maintainable. What that is, I have not seen yet, but that is Mardia. So after Mardia, you had people taking recourse to civil, only to the DRTs. But you also had a case where every person, so there were a lot of people who said, the bank promised me 100 crores, they only gave me 30 crores, so my business failed, so I'm going to make what is called a lender liability claim. So then the question arose as to whether this suit is maintainable or not, or whether we can only the DRT has jurisdiction. All of this came before a bench of the Honorable Supreme Court called Nahar Industrial Syndicate, which is 2009, volume 8, SEC 646. There Supreme Court said counterclaims are maintainable and DRT does not bar the jurisdiction of civil court to decide a lender liability claim. So this obviously led to a lot of people filing suits for the civil court. So the legislature jumped in, tried to amend the RDB Act by giving power to receive and hear counterclaims. So then the question arose as to whether after the amendment, suits filed in civil court can be tried as counterclaims for the DRT. That in a very recent judgment, Honorable Supreme Court in a case called Bank of Rajasthan versus VCK Broking, which is 2023 volume 1 SEC page 1, has said that the civil court's jurisdiction is still not barred and suits filed for lender liability claims will not be transferred to DRT. So now let's go back now to, we left off at 2009. So after the SARFAESI Act came to be fully enforced, we had, when I say we, I mean bank lawyers, we started seeing people filing partition suits, suit to declare the mortgage is null and void, suit to declare that the mortgage was given without proper authority. These kinds of suits started to be filed before the civil courts. So the question is, are these kinds of suits barred? I'll talk about partition last because it's the most troubling aspect of the bar. In Jagdish versus Hira Lal, which was a suit for, no doubt for partition, but also for declaration of title and for injunction, the Supreme Court said the bar under section 34 is absolute. If the suit has the effect of interdicting SARFAESI action, it's barred. So that was the broadest expanse we had seen until then. And with that, hundreds of suits started getting knocked out. One example I can give from my personal experience is a case called Subramaniam versus HSBC. Subramaniam is, of course, the famous Sudiksha chap who's now in jail. Illa sir, he's arguing case from jail, sir. Nethi from jail and argue panna, sir. So, sir, keep him in jail, sir. So he filed a suit for a declaration that the guarantees given by him are null and void, and for injunction against the DRTs in proceeding with the suits. His Lordship Satish Kumar held that the suits are not maintainable and rejected all the claims, affirmed an appeal. I don't know if a SLP was taken, but it was affirmed an appeal. Then we had a case where, this is an interesting one, this is Robust Hotels versus I think Escorts. That is a case where a suit for specific performance was filed against a party. So the borrower had entered an agreement to give a portion of property to Robust Hotels, and they had also defaulted to the banks. So the question was whether the suit by the agreement holder would bar any remedies would be barred by provisions of the DRT or SARFAESI Act. And the Honorable Supreme Court held that is not barred. So that is Robust Hotels. But then, by the same token, in a case called Madhav Prasad vs. Axis Bank, which is 2019, Volume 7, SEC 158, Honorable Supreme Court held that a performance suit which has the effect of denuding the bank of its rights in the SARFAESI Act is not maintainable. So you have two cases which don't sit very well together. Then there was a very ingenious suit which my senior and I had the pleasure of arguing, which is we filed a suit to declare that the assignment deed by a bank to an ARC is null and void, and for some other reliefs. And we also said we put in the word fraud. But the chief at that time was Justice Sanjeev Banerjee. So rubbish was and we got thrown out. Affirmed. And so we lost, and the Supreme Court also said that your remedies for DRT. So a suit for a declaration that an assignment did. So we were questioning the very mortgage itself, but even that was held to be barred by Section 34. So then we come to partition suits, and this is a bit troubling because there are judgments both ways. In the case of a partition, you have a person who says that the mortgagor did not have the full title to mortgage. Now, what is the right of that person? Clearly, they cannot injunct a SARFAESI sale by filing a suit for partition. So they can file a partition suit, but then what? Now, the Supreme Court in Anand Kumar versus IOB, which is 2019, Volume 14, SEC 788, said that once SARFAESI is initiated, partition suit is not maintainable. Even Jagdish vs. Hiralal is a partition suit, but there the facts were egregious. So I'm not going to go into that. Now, within our High Court, there was a matter which I argued, which is called Arcel versus minor Shreya Chitrobi, where it's not reported. First appeal 848/18, suit for partition not maintainable. And the Honorable Court said that if you want to claim a share, you file an appeal before DRT. Now, the exact opposite view has been taken by Justice Lakshmi Narayanan in a case called IDBI versus minor Hari Adarsh, which is 27th September 2023, where he held that partition suit, DRT has no power to grant shares. Therefore, clearly the suit is still maintainable. And he also distinguishes Jagdish Hiralal, saying that that was a case where on facts itself, the partition suit was filed on the basis of mortgage had taken place. So you will find that these there are judgments both ways and they don't sit easily together. There's also a recent judgment of Her Ladyship, this is Manjula, called Punjab National Bank vs. Lalita, 2023, Volume 4, Law Weekly, page 880, where that was a case where there was an X. X had an agreement of sale with the plaintiff, Lalita. Now, X then sold the property to Y. Y mortgaged to Punjab National Bank and defaulted. So now, Lalita files a suit against X saying that having entered an agreement with me, you've suppressed everything, you've given the original title deeds to me, and you've gone and sold it like this. Therefore, my suit for performance and also fraud is alleged. The bank filed a rejection of plaintiff application under 34 saying that you're in effect questioning the mortgage. And all the judgments I've mentioned here were all cited, but her ladyship held that this particular question, since you're questioning not the mortgagor's right to mortgage, but the mortgagor's vendor. So she said that this is nothing, the DRT has nothing to do with this. So the suit was maintainable, reject the plaintiff was dismissed. I don't know if the matter was carried on further appeal. So what you're finding is that there are aspects where the courts are grappling with conflicting rights. So in the case of a partition, what if a person has a right by birth? The father mortgages possibly in ignorance of the person's right or knowing the person's right to defeat it. Can the bank sell it? If the bank has sold it and you say that suit is not maintainable, do we go to the DRT and say that, look, you please sell only 3/4 share? I don't think a DRT can adjudicate on those things. So what is the position? That's one thing. Then performance suits are again another troubling aspect, because the law is settled that no injunction can be granted in respect of SARFAESI action. So if your suit is pending for 5-6 years, and in the meanwhile the bank property has been sold, what is your right? Because it's not as though you can go to DRT and stop the sale saying I'm an agreement holder. So that is one aspect. Then we find, what is the case of unregistered tenants who want an injunction in respect of protection of the possession accepting by due process of law? Section 17(4) capital A of SARFAESI Act does give a right of appeal to tenants before the DRT. But that is hemmed in by certain conditionalities which are spelled out in 3 cases, Harshad Sondagar, and then Kalsaria, Vishal Kalsaria, and one lady's name. So there are conditions. So you can't even approach the DRT unless you are having a registered lease or your lease precedes the action under SARFAESI Act. So can an unregistered tenant proceed before the court? And lastly, can the mortgagor file a suit for redemption? That's again a question which is yet to be tested. You could argue that there's a section 13 subsection 8, but even that has conditionalities attached to it now. Earlier it was an open right of redemption. Now the right of redemption under 13 can be exercised only prior to a sale notice. So the suit maintainable now post sale notice? We'll have to see. So to sum up, what I want to say is where there are rights, I'm going to end with where Om sir started. Where there are rights, there have to be remedies. So if the Act leaves something, if there's a gap in the Act, we have to find a way to ensure that the party is not left without remedy. And therefore, I would submit to this august audience that the civil court's remedies should not be barred in such cases. Thank you.
This question and answer session. Any advocate juniors would like to have questions in this topic, please. A wonderful topic and wonderful speech. Now I request additional solicitor and Sundari, the senior advocate, to put a shawl to both the senior.
Single shawl.
Two shawls. Now I request Parthasar, senior advocate, to present a memento to both the senior counsels. Now vote of thanks by Secretary.
Senior advocates Mr. Om Prakash and Srinath Sridevan, I profusely thank for this wonderful session, because originally we were disappointed when they said that senior advocate is not able to make it today. We were wondering, but suddenly they just made it a very great lecture, because immediately within a short span of time preparing so much of materials and delivering it not that easy. The way they've delivered shows the kind of a knowledge they possess. They possess a wonderful, great knowledge. They've shared it within a short span of time. I think all would have enjoyed it, because reading and learning it is very, very difficult task. And as a young lawyers, by listening to this, it will be a treat to the ears for the practicing lawyers. So please do attend. Please do make use of this kind of a knowledge sharing. And I thank all the senior forum. This thing is A.L. Somyaji is a convener, Mr. S. Parthasar the co-convener, and Mr. Om Prakash secretary for this arranging this wonderful session. And the next session will be on 4/4/2024 on civil appellate jurisdiction by senior advocate T.R. Rajagopalan. Please do come and make it a grand event. Thank you very much. Sir. Wonderful.